Today, Nigeria and the British High Commission signed a deal to bring back the looted funds by former Delta Governor James Ibori and some of his friends. And the People's Democratic Party, PDP, says it is not being served a court order stopping the South-South Zone Congress, an election held in Port Harcourt today, in spite of the court order from Calabar. Hello, everyone, and welcome to Politics Today, live on Channels Television. I'm Sean Wakimalo, our Channels Television Global Headquarters here in Lagos, Nigeria. Our special guest on the program is already seated in our Abuja studio, and tonight we'll be looking at the Buhari anti-corruption war, especially some of the funds that are coming from the United Kingdom, stolen from the Delta State government. That is in the administration of the former governor, James Ibori. But just before we get into that, everyone, let's tell you that the People's Democratic Party, PDP, today held its South-South Zone Congress in Port Harcourt in the River State capital. Despite an order from the court suspending the exercise, the PDP told Channels Television that it has not been served any court order restraining it from holding the delegates' election. A high court in Calabar, the Cross River State capital, had issued an order that the Zone Congress be suspended pending the hearing and determination of the motion on notice. When Channels Television visited the designated venue of the Congress at the Obiwali Cultural Center, many of the leaders of the party, including governors of the party in the South-South region, are seen casting their votes after accreditation process. Of course, let's show you that court order that was served today from the court in Calabar. That is it right there. But the PDP said that they have not been served. It's stated under that court order that it could be served by substituted means. Our focus tonight, everyone, is perhaps the biggest news story of the day, where the United Kingdom says it will return £4.2 million of stolen assets linked to the former Delta State Governor, James Ibori, to the federal government. The British High Commissioner to Nigeria, Catherine Lane, at the signing of the Memorandum of Understanding, says the money was recovered from friends and family members of the former governor. She frowned at the way many Nigerians siphon money from the country to the UK, which she says has affected the level of trust between the two countries. Mrs. Lane, however, warned that the UK will no longer be used as a destination for looters to siphon proceeds of crimes. The Attorney General of the Federation and Ministry of Justice, Abubakar Malami, explained that the recovery of the stolen fund is part of efforts by government to fight corruption. He said that the money will be used for the construction of the second Niger Bridge, Abuja-Kano Road, and the Lagos-Ibadan Express Road. Based on the agreement signed, the £4.2 million is to be returned in 2 weeks' time. Tonight, we have the Attorney General and the Minister of Justice, the man who signed that Memorandum of Understanding, perhaps a milestone in his office as regarding the anti-corruption war under the Buhari government. Mr. Abubakar Malami, Senior Advocate of Nigeria, he joins us from our Abuja studio to give perspectives on this issue. Thank you, AGF, for joining us tonight on the program. And I must say, perhaps congratulations.
Thank you for having me.
Thank you so much. Congratulations on this recovery. But let's begin the conversation, AGF. You mentioned in your remark earlier today that the money was recovered from Mr. Ibori and his friends and allies and family members. Could you tell us, who are these people aside the former Delta State governor?
Well, as far as the composition of people is concerned, I think the fundamental issue of consideration and of interest to Nigerians is Ibori is the principal character. And being the principal character, he had indeed stood trial and was accordingly convicted. And then arising from that conviction, these recoveries of today are being made. As to the details of who are involved, associated judicial proceeding is still ongoing. And in fact, the amount that has been signed to be repatriated today, which is £4.2 million, is indeed a fraction of a larger amount rising, which is within the region of over 100 million pounds, which is still, subject to judicial proceedings. But then as time goes on, at the appropriate time, we will make adequate disclosure as to the extended family members that are involved. But for now, the matter being sub judice, I think we can leave it at that. Ibori is involved, other family members are involved. Ibori has been convicted, and 4.2 million pounds, constituting a fraction of the amount being pursued by Nigeria for repatriation, is indeed confirmed to be ready for repatriation in the next 2 weeks.
Is any part of this money going to the coffers of Delta State government? Because lawyers will say or argue that since the money was looted from the Delta State government coffers, shouldn't that amount be returned to the Delta State government?
At any rate, I think the major consideration relating to who is indeed entitled to fraction or perhaps the money in its entirety is a function of law and international diplomacy, among others. Function of the law in the sense that with the law in contention that was alleged to have been breached is a federal law. That is a starting point. And then secondly, in dealing with international community and international diplomacy, the parties of interest are the states parties and not subnationals, are the national and not subnational governments that are involved. And with those backgrounds in mind, all the processes associated with the recovery are processes consummated by the federal government, and indeed the federal government is the victim of crime and not subnational. The law is a federal law that was alleged to have been breached, and then the parties are nationals and not subnationals, UK government where the money was eventually looted to, and then the Nigerian government that had pursued the recovery of such money. Whether Delta State government will benefit from it or will not benefit from it is a function of local law, but certainly the agreement as consummated by the parties is for the benefit of the for the Nigerian state as a victim of crime and not the Delta State government as subnational.
Is it, does it not look like a double standard, considering that in the case of the £5 million recovered from the funds stolen by former Bayelsa State Governor Depriye Alamasia was handed back to the state government in 2012. According to Tafida at that time, the money was received from the British authorities in similar situation and handed over to two government officials from Bayelsa State. This is a similar situation where we find former governors who were convicted of crimes of defrauding their state, and the monies were being said to have been taken back to the state government in the case of Bayelsa and Alamasia.
Well, as I stated earlier, it's not an exclusive function of a local legislation. It is indeed a function, and the recovery process is a function of mutuality. Mutuality in the sense that Nigerian government and the foreign government is involved. Over and above the legislative aspect and statutory aspect of it, you equally have to factor the negotiations element. In 2012, for example, Kano-Abuja Expressway, Lagos-Ibadan Expressway, and a second mainland bridge were not factored into consideration by way of the application of the fund. In 2020, 2021, the agreement negotiated factored this element into consideration. That, in essence, establishes the fact that it is a function of negotiation among others. And as such, it's not about the double standard per se, but about the negotiations, the terms and clauses arrived at and reached often by the parties arising from the second component of legislation, a breach of the local legislation, international dimension of it, taking into consideration that the international community or perhaps a foreign country involved in the repatriation exercise equally must naturally be engaged in terms of negotiations for the purpose of arriving at terms. So it is more or less a function of international engagement, international negotiations, international agreements, and then the agreement eventually reached among the parties. So the idea of double standard does not arise because each and every case has its peculiarities and must naturally be treated on the basis of its peculiarities. There is no uniform negotiation processes involved in each and every case. Each and every case has independent, exclusive peculiarities that naturally comes to mind at the point of negotiations and agreement among the parties.
So let's get it clearly so that Nigerians can get a sense of what the work that you have put into this. Did the British government insist on what these monies must be used for before they agreed to repatriate the funds? Is that what happened?
British and Nigerian government discussed, negotiated, and agreed on where and what. So it is not a matter of insistence, but a matter of negotiations between two sovereign nations, two sovereign states, and then arising from the protracted negotiations that lasted for over 6-7 years, parties come to terms and are in agreement. But you should need to understand clearly that these projects are legacy projects that the federal government, under the leadership of President Muhammadu Buhari, has been committed to, has been very much interested in their completion, arising from its desire to provide the desired infrastructure to the Nigerian nation.
Another very area that we need to get clarity from you is the worries of what this process looked like. It's almost over 8 years now since Mr. Ibori was convicted. Why has it taken that long to get the money repatriated to Nigeria?
Well, as far as the law applicable in UK is concerned, repatriation or recovery of looted asset is a function of judicial process and can only be factored to mind by way of forfeiture process, often conviction. So it is indeed after the conviction that the idea of perhaps repatriation and recovery and repatriation can come into play. So, and as you rightly know, judicial process is indeed a function of hierarchical consideration. First, trial court, trial high court, court of appeal, down to the Supreme Court. The same thing that obtains in Nigerian situation whereby you require a lot of time for the purpose of concluding, consummating, and indeed prosecution and conviction. The same thing applies to the judicial system in UK. And that by implication means the idea of forfeiture, the idea of recovery, and the idea of repatriation must naturally await judicial process of conviction before initiation of the forfeiture process, as against the Nigerian system whereby you may have interim orders of forfeiture, civil forfeiture, among other considerations. So it is indeed a function of judicial process that had indeed hampered the speedy repatriation and recovery of the looted assets.
Can you give us an understanding of what part of the world or which exactly are you chasing in some of the looted funds, perhaps if you are on the verge of having a breakthrough?
Well, I think we have no impediments as far as what and where we are looking at. For example, as you rightly know, in 2017, we succeeded in recovering about $322 million from Switzerland. And then from there, we proceeded to UK, US, and Jersey, where certain funds associated with these jurisdictions were as well recovered in 2020, where we succeeded in recovering about $311 million. Recently, again, we succeeded in recovering about 5.4 million euros from Ireland. And again, we are, as it is now, succeeded in recovering 4.2 million pounds from UK. We are still pursuing other assets, inclusive of the fact that even as it relates to the Ibori's asset, the quantum of the amount involved was within the region of over 100 million pounds, and that it is out of it that we have succeeded in recovering a fraction of 4.2 million pounds, and we are still pursuing additional sum within the region of estimated region of 100 million pounds, and that will, as I stated earlier, be a function of conviction and subsequent recovery process. So we are targeting that asset among others. There is still another component of Abacha assets that is as well being pursued for recovery, and that is within the region of over 100 million dollars as well. So we are indeed pursuing assets wherever it is, and additional assets are being traced for recovery internationally. So we are not in any way a kind of restricted in terms of geographical location and jurisdiction as far as the recovery of assets are concerned, but the assets that we are now pursuing within the immediate reach is additional component of the Abacha assets, additional component of Ibori assets, and these are some of the assets within the region of over 200 million to 100 million pounds relating to Ibori, and over 100 million additional pounds relating to Abacha, over and above some other small components of assets being targeted in other jurisdictions.
Let's take a breather, AGF. When we come back, there are other issues regarding the effort of the federal government on the anti-corruption war. Where they are, the questions on the minds of many Nigerians. We are here to ask them tonight. We have the Minister of Justice, Abubakar Malami, SAN, with us. I'll be right back after this time out. Join us again, everyone. Thank you so much, everyone, for staying with us right here on Channels Television's Politics Today. Tonight, the Attorney General of the Federation and the Minister of Justice, Mr. Abubakar Malami, Senior Advocate of Nigeria, has been talking to us and is in respect of the news regarding the return of some assets looted by former Delta State Governor James Onanefe Ibori. Thank you so much, AGF, for talking to us right here on Channels Television. Let's get back to the conversation. And perhaps let me quickly get, you told us about some other looted asset. One of a case that a lot of people have in mind is the P&ID case. About that matter, what can you tell us? What is the latest?
Well, the latest is necessary court processes were filed mutually by the parties, the defendants, the claimants, and indeed, the appellants and the respondents have all put in their papers. And along the line, additional witness statements are equally being filed in readiness for the final hearing. But I think, as you rightly know, it has been a success story all through. Success story in the sense that we were at a point, our assets locally and internationally was at a point being considered for attachment and settlement of judgment debt running over 9 billion dollars. And then we succeeded in terms of stopping the enforcement of such judgment. That constitutes a success story because it could have been a different story by today if indeed our assets locally and internationally were attached for the purpose of settling that judgment sum of over 9 billion dollars. So with that, an appeal was lodged. We were equally demanded by the court to pay cost of over around 200 million as a condition for stay of execution, stay of enforcement of the judgment. We appealed against that ruling, and we had a further success story that set aside the order demanding us to effect such payment of such amount. And then in place of the payment of the sum, we were requested to lodge a bond, perhaps a bank guarantee. We equally appeal against the ruling demanding us to lodge to make available a bank guarantee or performance bond, and we succeeded further by of having that order set aside as well. We equally applied for international interrogatories seeking certain documents to support our case in proof of fraud and proof of corruption and associated things internationally. P&ID made an attempt to stop us from getting those documents from the international financial institutions. And then we succeeded as well in having order granted in our favor, which gave us further opportunity to make associated interrogatories, inquiries internationally, and obtain documents. And with that, we succeeded in consolidating on our case by way of establishing fraud. And as it is now, the case is set for final hearing, and that is what we are looking at. And taking into consideration the success stories all the way, taking into consideration the fact that our case has further been consolidated from the perspectives of establishing fraud, from the perspectives of establishing corruption, I think it is indeed greater success story full of optimism that at the end of the day, we will, by God's grace, triumph by way of, taking into consideration the likely outcome associated with the case. So the nutshell, the summary of what I'm laboring to state is that ever since we took a decision to challenge that judgment, it has been a success story all the way, and then our position as a government is being strengthened day in, day out, and we are very optimistic at the end of the day, taking into consideration the justice and fairness of the judicial system in UK. We will, by God's grace, be happy at the end of the day, and we expect a very positive outcome. We have a strong case that is becoming more stronger by the day, and we are very hopeful and optimistic. So the position we are is the final determination of the case, and necessary witness statements have been indeed filed in the court processes in readiness for the final determination of the case.
Okay, so I have some quick questions. Before we lay to rest on the program on the issue of Ibori matter, how did you arrive at plowing that 4.2 million pounds into those 3 projects that you mentioned earlier today? And if you look at those, the money that you're talking about, 4.2 million, is not going to cover the cost of the 3 projects that you have mentioned. Is it just going to be for some of the ancillary expenditures, or what exactly, or which area of this project are you going to spend the monies on?
You see, the federal government has been before now investing and making appropriation and budgetary provision for these projects before now. So it is not that this 4.2 million pounds is exclusively the amount in the kitties, in the coffers of the federal government for the purpose of execution of that project. But it is a project that is based on milestones in terms of funding. As you rightly know, at the point of mobilization, by the prevailing policy of government, 15% of the entire amount is what is expected to be paid. And then along the line, you keep funding the project. So what we have been trying to do is to ensure that the provision of adequate fundings for the project over and above the appropriation and indeed budgetary provisions that have been made. So the $311 million that were earlier on recovered from US, island of Jersey, and UK were applied for the same project. This additional 4.2 million pounds will be applied for the same project under the management of Nigeria's Sovereign Investment Authority. So what I'm saying in essence that the conclusion of this project is a component of the budgetary provision, component of recoveries made, and indeed previous recoveries made with particular reference to $311 million US dollars, and indeed this other component. And again, the government taking into consideration its commitment to the conclusion of the project and its timely delivery will still continue funding the project. But the bottom line is that we are interested in delivering these projects within record time, and the resources relating to it is being mobilized. That is the bottom line. So it is about consolidating on the existing budgetary provision, consolidating on the existing recoveries made and applied, and then added to what we have gotten now arising from this repatriation exercise, or what we get arising from the recovery exercise.
A quick reaction from you. You have been subpoenaed and compelled to testify in the case in the Federal High Court involving Mr. Abdulrasheed Maina. Have you gotten that subpoena, and will you be appearing to testify in that matter?
Well, I have not been served with any subpoena as it is. But then, when the subpoena is served, we will look at it within the context of the law and the public interest for us to arrive at a decision. It is too early in the day for me to kind of arrive at a decision speculatively, taking into consideration, one, the subpoena has not been served on me, and then on the Office of the Attorney General, and then two, we look at the subpoena within the context of the law and the public interest, with the Office of the Attorney General of the Federation is established to protect and then do the needful. But then, as it is now, it amounts to a speculative question that I wouldn't like to answer.
Perhaps our final question with you, Honorable Minister, tonight is a case involving the former governor of Lagos State, Bola Tinubu. Confirm to us if your office, in conjunction with the EFCC and the CCB, has reopened a case against him.
The Office of the Attorney General, as you rightly know, has not taken any decision, has not filed or instituted any action before any court in the land relating to Asiwaju Bola Ahmed Tinubu. But then, within the context of the law, as you rightly know, the EFCC, the Court of Conduct, are all statutory bodies that are vested with statutory powers to act within the context of the law establishing them. So I am not in a position to give you a precise answer, and I will suggest to you that you may perhaps consider inviting the chairman of the EFCC or perhaps the chairman of the Court of Conduct for elaborate answer associated with those charges, if any, has been filed by any of such agencies. I am not here in a representative capacity to speak for them, neither in a defensive capacity for them. I would suggest that you invite the heads of those agencies to perhaps shed more light. But the Office of the Attorney General and its arm, which is the Office of the Director of Public Prosecution, has not initiated any proceedings, and no investigation has been instituted at its instance by any agency of the government, be it EFCC or indeed the Code of Conduct. Okay,
we're out of time now, I'm being told. But do you plan to, or have you approached the president to scrap PACAC that is being headed by Professor H.S. Sage? Have you told the president anything in that regard?
Not at all.
Honorable Minister for Justice and the Attorney General of the Federation, Mr. Abubakar Malami, Senior Advocate of Nigeria, thank you indeed for your time tonight and for clarifying and informing Nigerians about some of these activities in your office and under the Buhari government. Thank you indeed.
Thank you, Shehu.
Appreciate it. And that's our show for today, everyone. Many thanks for watching. I'm Shehu Akim Aloye. Bye-bye.